Universities devote a lot of time putting together policies and procedures, and that would include how you handle an investigation, how you handle these hearings. And we've been involved in helping to develop those processes, right?
Absolutely. So in the Obama years, the Title IX guidance and regulations were really sort of geared to this idea of fairness. They were very broad. They required a lot of reporting. They required significant investigations and a dedication of university resources in a way that changed in 2016. In 2016, we found that while some of the ground rules were still the same, we now needed a new set of Title IX personnel to sort of devote to the process. And that was because everything was all of a sudden more technical. So previously, when you may have had a university administrator or faculty member actively involved in Title IX investigations, that came with risk under the new Trump-era regulations because of the sort of more formality and sort of legalistic requirements of the new rules. Colleges and universities really were scrambling to sort of restaff and sort of reconfigure both their policies, which we were actively involved with, and also restaffing the process in a way that would reduce the risks of being sued at the other end of things for non-compliance with either the regulations or, in some instances, their own policies and procedures.
What we've got is a context of a lot of regulation, changing regulation, going back and forth, a need to invest a lot of time and money and resources into staffing, development of policies, and then lots of training as well for higher ed institutions.
Absolutely. And really, one of the issues especially for smaller colleges and universities were already strapped for resources for non-Title IX activities, were now all of a sudden required to devote significant resources to developing policies. Typically, most colleges and universities develop sort of a two-track investigation process. One track more formalized for the new Title IX investigation process. So the formal process applied to fewer instances of sexual misconduct, but then sort of a broader, less formal investigation process that applied to sort of less serious sexual misconduct claims. So you really had the universities sort of responding on two fronts.
So those less serious cases might involve student misconduct under the requirements in the student handbook, but might not rise to a level that would meet the Title IX definitions of harassment that were the newly promulgated regulation.
Exactly. Yeah. So it was sexual misconduct that previously would have been treated as a Title IX matter, but under the new sort of narrower definitions in the 2020 regulations, you had a whole sort of category of sexual misconduct that before would have been handled one way, but now sort of fell outside the formal process. So you had an investigation process that looked like the old investigation process that most colleges and universities used, less formal, designed to sort of be fair to both sides, and then a more formalized process that looked a lot like a judicial proceeding in the sense that you had sort of formal evidentiary issues, attorney representation, a hearing officer who really had to function more or less as a judge, making rulings, objections to evidence and things of that nature in real time, something that lawyers like us, as experienced as we are, would have trouble complying with. So the feeling was that inadvertently these new rules with the significant formalities really created the potential for a lot of gotcha issues. If you missed one of the formalities, despite your best efforts, you could wind up in an actual court for failing to comply with these new Title IX investigation formalities.